If you've been meaning to get a will done and haven't gotten around to it yet, you're not alone. Most people put it off, not because they don't care about their family, but because it feels complicated or uncomfortable to think about. The truth is that getting a will done and put in place is one of the most straightforward things that you can do to protect the people you love. I am Asthana from Southern Estate Lawyers, and we help Alabama families create wills and estate plans that are clear, legally sound, and built around what matters to these families. Let me walk you through what you need to know. A will is not just for people with large estates. If you have children, a home, savings, or anyone you wish to provide for, you need a will. Your will does three big things. It tells the court who inherits your property, who manages your estate, and if you have young children, who raises them if something happens to you. That last one is one of the most important reasons why many families finally sit down and get this done. If you pass away without a will in Alabama, the state decides who gets your assets. And that process is called intestate succession. It follows a strict formula and it has nothing to do with what your intentions and desires may have been. If you're married with children, your spouse does not automatically receive everything. If all of your children are also your spouse's children, your spouse receives the first $50,000 plus half of what remains, and your children split the other half. If any of your children are not your spouse's, the estate is divided equally between your spouse and children. If you're married with no children but your parents are living, your spouse receives the first $100,000 plus half of the rest, and your parents inherit the remainder. And some people that you love receive nothing at all. Unmarried partners, stepchildren you never legally adopted, close friends. A will puts all those decisions back in your hands. For a will to be valid in Alabama, a few requirements must be met. You must be at least 18 years old and of sound mind when you sign. 2 adult witnesses must watch you sign or watch you acknowledge your signature. A beneficiary can legally witness your will, but it's better to use witnesses who inherit nothing, so no one can later question the will. One detail that saves families time is to make sure that your will is self-proving. All that means is signing your will in the presence of a notary, so that when it's submitted to probate later, the court does not have to spend time tracking witnesses. A strong will does way more than naming just who gets what. It names an executor, a person who will carry out your wishes. It names a guardian for minor children. It can create a trust inside the will named a testamentary trust. It helps control how younger or disabled beneficiaries receive money. It includes a residuary clause, which catches everything that you may not have mentioned, so it leaves nothing to chance. And in a will, you don't have to list every personal property possession. In Alabama, you can give your executor full authority to distribute your personal property items. For such items, the law provides for you to leave a personal property memorandum to the executor, laying out your wishes as to what needs to be done with which item. The personal property memorandum is a list that you can revise at any time without having to revise your will. And a well-drafted will can save you time and real money from the very beginning. In Alabama, when a will goes through probate, the court will default to requiring 3 things from your executor: posting a bond, filing an inventory, and filing a detailed accounting of the estate, and that is yearly. Each one takes time and it's expensive, but your will can waive all of those requirements. Waiving a bond means that your executor does not have to purchase an insurance policy, a premium that is paid out of your own estate funds, just to do the job that you have asked them to do. Waiving the inventory keeps a detailed public record of everything you owned and what it was worth out of the court file. And waiving the accounting removes the need to prepare extensive court-ready financial statements showing and accounting for every dollar that moved through the estate. None of these waivers are automatic. They have to be specifically addressed in your will. Often when people use a generic form from the web, these types of specific details and nuances are often ignored, and missing any one of them can add substantial cost and delay to the process. 2 things people almost never think about. First, your digital life. Online accounts, photos, cryptocurrency are all part of your estate. Alabama law lets you give authority to your executor over those digital assets, but only if your will actually says so. Without that, your family may get locked out of those accounts. Second is property located in another state. If you own real property outside of the state of Alabama, a separate process may need to be pursued in that state, and that is referred to as ancillary probate. A few mistakes come up again and again. Using an online template that ignores Alabama's specific requirements. A generic form can miss a formality of Alabama law that can render your will invalid. Another mistake is not naming a guardian for minor children. Next, failing to mention what happens if a beneficiary that you intended to receive property passes before you. And lastly, signing a will once and putting it aside, never looking at it again. Now, there are a few things that a will cannot do. It does not control accounts that already have named beneficiaries, like life insurance policies and retirement accounts. Those pass directly to whomever is named on those accounts as beneficiary, no matter what your will says. A will also does not avoid probate. It still goes through the entire probate process after you pass. If avoiding probate is a priority to you, make sure to discuss a revocable living trust with your attorney. If you already have a will, well, that's a great start. But a will is not a set it and forget it document. It's good practice to review your will every 3 to 5 years or sooner if something significant happens, like a marriage, a divorce, or a birth or adoption of a child. If you need to change your will, a small change can be made with a document named codicil. However, best practice is probably just to do another new will. A couple of Alabama-specific rules are worth noting. While your individually owned property is yours to leave as you choose, but Alabama law protects a surviving spouse with what's called an elective share. Even if a will leaves spouseless or cuts them out entirely, the spouse can claim the lesser of 1/3 of the estate or the whole estate minus the value of their own separate property. And if someone wants to contest an estate after the will has been admitted into probate, Alabama gives them only 180 days from the date the will was admitted into probate to, depending on the county, file the contest in circuit court. A properly drafted and properly witnessed will is the best protection against a challenge like that. As Southern estate lawyers, we make this whole process straightforward. We start with a free consultation to understand your assets, your family, your goals. From there, we draft a will that meets all of Alabama's requirements and reflects exactly what you want. We explain every provision in detail so you know exactly what you're signing. And because we also litigate estate disputes, we draft your will to hold up if anyone ever challenges it. A will is often just a starting point. We may also recommend a power of attorney, healthcare directive, or a trust. We have offices in Foley, Mobile, and Birmingham, and we offer phone and virtual consultations. If you've been putting off getting a will in place, let this be the moment that you stop waiting. It doesn't have to be complicated, and it doesn't have to take long. Call Southern Estate Lawyers to schedule your free consultation. We look forward to working for you.